So friends, Judge Aileen Cannon continues to do extraordinary favors for the defendant to whom she owes her job, Donald Trump. Hey all, Glenn Kirshner here. So friends, can we talk about Trump-appointed Judge Aileen Cannon and the unshakable concern I have that she's setting things up to break bad for the prospect of Donald Trump being held accountable for his crimes in his federal case down in Florida. On Thursday, Judge Cannon heard oral arguments for hours on two of Donald Trump's motions to dismiss his case. One of those two motions, actually both of them, but we're going to focus on one today. One of those motions was an absolute no-brainer because it was entirely frivolous. That is Donald Trump's claim that the Espionage Act is unconstitutional. Donald Trump is charged with violating the Espionage Act, our nation's espionage laws. He's charged with 32 federal felony counts in violation of the Espionage Act. The Espionage Act has been on the books since 1917. The Espionage Act has been used to prosecute people countless times. People like Julius and Ethel Rosenberg, John Walker, Aldrich Ames, Robert Hansen, and other infamous spies and traitors. And each and every time the Espionage Act was challenged in the courts, it was held to be constitutional. But Donald Trump now says, more than 100 years since it was enacted, no, it's unconstitutional under the doctrine of what's called void for vagueness. That is actually a doctrine in the criminal law. If a statute is so void, no one can understand it, no one can make heads or tails of it, we don't even know what conduct it criminalizes, it could be unconstitutionally void for vagueness, but the Espionage Act is not. Still, that was one of Donald Trump's two motions to dismiss that was argued for hours in that federal courtroom down in Florida before Judge Aileen Cannon on Thursday. And Judge Cannon, for the time being, denied Donald Trump's motion attacking the constitutionality of the Espionage Act. We're going to start with the reporting, then we're going to look at Judge Cannon's basically one-page ruling denying, for the time being, Donald Trump's motion to dismiss, and then we're going to talk about what's really going on here. Let's start with the new reporting. This from HuffPost. Headline: Judge rejects bid by Donald Trump to throw out classified documents case on constitutional grounds. And that article begins, a federal judge on Thursday rejected a bid by Donald Trump to throw out his classified documents criminal case and appeared skeptical during hours of arguments of a separate effort to scuttle the prosecution ahead of trial. U.S. District Judge Aileen Cannon issued a two-page order saying that though the Trump team had raised various arguments warranting serious consideration, a dismissal of the charges was not merited. But friends, what's really going on here? What is Judge Cannon doing, and what might she be trying to accomplish? Well, for that, I want to quote my friend and fellow legal analyst, Joyce Vance. Joyce is an appellate guru, an appellate expert, and this is her take on it as reported by Salon. Quote, the judge's ruling was virtually incomprehensible, even to those of us who speak legal as our native language. Former U.S. Attorney Joyce Vance wrote on Substack, calling part of her, Judge Cannon's ruling, deliberately dumb. I would go a little bit farther. I don't know that it was deliberately dumb. I don't know that that's how I would characterize it. I would call it downright nefarious. Put a pin in that. Joyce continues, "The good news here is temporary," Vance wrote. "It's what I'd call an ugly win for the government, for the prosecution. The judge dismissed the vagueness argument, but just for today. She did it without prejudice, which means that Trump's lawyers could raise the argument again later in the case. In fact, the judge seemed to do just that in her order, essentially inviting the defense to raise the argument again at trial." Vance noted that if Cannon had ruled against the government on Thursday, Smith's team could have appealed. Quote, "But that's not the case if, after today's ruling in the government's favor, she, Judge Cannon, permits Trump to resurrect the motion at trial," Vance explained. "She could grant the motion to dismiss then, and at that point, with very rare exceptions, that the judge would be in a position to prevent, the government can't appeal. It all gets thrown out. The prosecution is over. Jack Smith can't appeal the motion to dismiss if Judge Cannon does it during the course of the trial rather than prior to trial, as she could have done on Thursday." Joyce continues, "That's because once a jury has been impaneled, double jeopardy attaches and prevents the government, the prosecutors, from retrying the defendant on the same charges if he's acquitted, which is what would happen if the judge granted a motion to dismiss at that point and before a jury rendered a guilty verdict. That's the nightmare scenario here." Friends, that's Joyce Vance sounding the alarm. Joyce is not typically alarmist, and Joyce is sort of the consummate authority on all things procedural, particularly when it comes to what can and can't be appealed and the consequences of a motion to dismiss pre-trial, which could be appealed by Jack Smith, or during the course of the trial, as Judge Cannon invited Trump's lawyers to do, and that can't be appealed. Case is over. So yes, I agree with everything Joyce said, with the possible exception of Judge Cannon just kind of being deliberately dumb. I mean, Judge Cannon comes across as incompetent, but it feels more like she has a nefarious purpose here, not just that she's incompetent or being deliberately dumb. But friends, with that, let's turn to Judge Cannon's order, her ruling. You know, friends, in my view, it's downright crazy that after this issue was briefed up by Donald Trump's lawyers and by Jack Smith's federal prosecutors, and after it was argued in court for hours, and the question was whether a 100-year-old statute, the Espionage Act, the federal criminal laws designed to punish traitors and spies that have been used over and over and over again for 100 years and always been found to be constitutional, never been found to be void for vagueness. After all of that, Judge Cannon issues a legal opinion that spans about 250 words and does not have a single legal authority cited, not a single case of precedent, not a single appellate court opinion, nothing. It is entirely without legal analysis. Let me give you something to compare it to. You know, Judge McAfee down in Georgia, who just issued a 23-page legal ruling saying that no, DA Fani Willis is not disqualified. She need not be removed from the RICO prosecution against Trump and his 18 co-defendants, criminal associates, co-conspirators. I just did a quick count in Judge McAfee's 23-page order, and in the body of it, I think he cites 45 cases as precedent, appellate court opinions, to support each and every legal conclusion he reached. And I didn't even count the ones in the footnotes, probably another couple of dozen. Judge Cannon, not a single case supporting anything she said in that page-and-a-half long order. that spanned, like I said, something like 250 words. Please bear with me, friends, because I want to read some of it, indeed most of it to you. It will be short. And I'm going to invite you to see if you understand it, because I don't. And just as Joyce Vance said, even to those of us who speak pretty fluent legalese, it is incomprehensible. With that, let's turn to Judge Cannon's recent opinion. In the case of United States of America versus Donald Trump, Waltine Nauta, and Carlos de Oliveira, defendants, this is Judge Cannon's order denying without prejudice, meaning I'm not really denying it, I am delaying it. I'm pushing it down the road. So I'm not denying it. What I'm doing is I'm urging you to bring it up again, Donald, during the course of the trial, when I can dismiss it with prejudice and Jack Smith can't appeal it. You may have already guessed you're going to get a good bit of editorializing by me as I read through this absurd, non-legal opinion. I can't even call it a legal opinion. It's a gift to Donald Trump. Order denying without prejudice, meaning you can raise it again at your pleasure, defendant Trump's motion to dismiss counts 1 through 32, those would be the espionage charges, based on unconstitutional vagueness. This case comes before the court upon defendant Trump's motion to dismiss counts 1 through 32, the espionage counts, based on unconstitutional vagueness. The Special Counsel, Jack Smith, filed a response in opposition, to which defendant Trump filed a reply. The court heard argument on the motion on March 14, 2024. Upon careful review of the motion, related filings, and the arguments raised during the hearing, not because she issued this ruling virtually as she was walking off the bench at the conclusion of the oral argument. So don't tell us you gave thoughtful, careful consideration of the oral arguments, Judge. Upon careful review of the motion, related filings, and the arguments raised during the hearing, defendant's motion is denied without prejudice. In other words, I'm just putting it off until later, and Trump and his lawyers can raise it during the course of the trial, when my ruling will do far more damage to the cause of justice. Yes, my editorial additions. Defendant Trump seeks dismissal of counts 1 through 32 of the superseding indictment on the ground that the statutory phrases, meaning the language in the federal law, the Espionage Act, the statutory phrases unauthorized possession, relating to the national defense, and entitled to receive, appearing in the law, 18 U.S.C. section 793E, are unconstitutionally vague. That's right, friends. We just can't figure out what in the world it means when the espionage law that's been on the books since 1917 uses phrases like unauthorized possession, relating to the national defense, and entitled to receive. So confusing, so vague. Can't make heads or tails of that, even though this statute has been used over and over and over and over and over again to hold accountable traitors and spies. Donald Trump maintains they are unconstitutionally vague. Although the motion raises various arguments warranting serious consideration, no, it doesn't. And I haven't found a single legal authority, left, right, or center, who said, oh, this motion raises serious legal issues, because it doesn't. It's frivolous, it's baseless, it's laughable, it's unsupported by any relevant appellate court precedent. Nevertheless, Judge Cannon says, although the motion raises various arguments warranting serious consideration, the court ultimately determines, following lengthy oral argument, there she goes again, that resolution of the overall question presented, now get ready for it, friends, because you're going to hear some judicial word salad here. The overall question presented depends too greatly on contested instructional questions about still fluctuating definitions of statutory terms, phrases as charged, along with at least some disputed factual issues as raised in the motion. For that reason, rather than prematurely decide now whether application of the law in these circumstances yields unsalvageable vagueness despite the asserted judicial glosses, the court elects to deny the motion without prejudice, to be raised as appropriate in connection with jury instruction briefing and or other appropriate motions. So she goes on to deny the motion to dismiss, but not really. She delays it. When you deny something without prejudice, it means the defendant can bring it up any time in the future that it suits his fancy. Like during the trial, when they're discussing the instructions to be given to the jury, which typically happens right before closing arguments, after the evidence is complete. It's all in. It's been presented and both sides rest their cases. That's when Judge Cannon suggests, maybe, Donald, you'd like to bring it up again then, because then, you see, if I grant the motion to dismiss, Jack Smith can't appeal it and all the espionage charges get thrown out. Boy, talk about doing an enormous favor, though, for Donald Trump. This is another reason, on top of several that have come before, why Judge Cannon and her impartiality might reasonably be questioned, such that Jack Smith should file a motion to recuse her, remove her from the case. Because can you imagine, even though Judge Cannon has sent this signal, can you imagine if the motion to remove her has never been made? We go through the trial, come instruction time, she says, Donald, remember, you wanted to re-raise that motion to dismiss. And Trump's lawyers do, and she says, granted, all 32 espionage charges thrown out. Can you imagine if Jack Smith had never filed the motion to remove her, motion to recuse? How foolish will we all feel looking back at this telltale sign? Judge Cannon is telling us what she intends to do here. I mean, she dismissed this in the most offhanded manner. No legal authority, no case law precedent supporting this, what she just did here. This is garbage. This is judicial word salad. This is nonsense. This works to Donald Trump's advantage, not to the advantage of justice or we the people. So I don't feel like I've been in the habit of trying to give advice to Jack Smith, because I think he has been doing one hell of a job, going hard as he can, after Donald Trump. Now, mind you, we still have a lot of unindicted co-conspirators that were in the Trump indictment, and we're still waiting to see when they're going to be charged, but Jack will get around to it. But if I could give him any piece of advice, it's that, the time to file a motion to kick her off the case, to remove her, to have her recused, because, as the federal law says, when a judge's impartiality might reasonably be questioned, the judge shall recuse from the case. File the motion, litigate it in the full light of day. Let the 11th Circuit Court of Appeals, which previously found that Judge Cannon abused her judicial discretion to the extreme advantage of Donald Trump, let the 11th Circuit Court of Appeals make this decision. Because then we will have done everything we can do to guard against what Judge Cannon just told us she intends to do. Do it.